Good afternoon. Thank you all for finding the time and joining today's webinar. My name is Mona Asghari and I'm a trademark attorney at Novograph in the UK. Our company is a leading international IP consultancy firm and the leading trademark representative in the EU, with the most EU trademarks and international registrations under our management at the EU Intellectual Property Office and at the World Intellectual Property Office. For more than 130 years, Novograph has been supporting iconic brands and innovative organisations. We work with national and international businesses to ensure the protection and enforcement of their IP through trademark, patent, design, domain names and copyright law. Our topic today is designing a brand development strategy that overcomes legal and commercial risks. And your speakers are my colleagues Vanessa Harrow and Laura Morris. Vanessa Harrow is Managing Director at Trademarks at Novograph in the UK, and Laura Morris is a Senior Trademark Attorney at Novograph in the UK. Vanessa leads the Novograph trademark business in the UK and has extensive experience in handling all aspects of trademark clearance, prosecution and enforcement work in a variety of sectors, including beverages, fashion, automotive, material sciences and consumer business. She advises a variety of clients from startups to large multinationals in the UK and EU, as well as internationally. Laura is highly experienced in all aspects of trademark work and focuses on the management of clients' global portfolios, including advising on cancellation proceedings, pre-action negotiations, clearance searches, recordals of assignments and licenses. Laura represents both established businesses and startups in a variety of industries, including automotive, fashion, technology, food and financial services. So we welcome any questions you have throughout the webinar. We will have a Q&A session at the end to answer your questions, which can be posted during the webinar via the dashboard. So at this time, I would like to hand over to Vanessa to begin our webinar.
Thank you, Mona, for the introduction, and thank you to all of our attendees for joining us today. Today we're going to be discussing the interplay between IP strategy and brand development. We'll be looking at this from a commercial perspective, providing some practical tips around creating a brand development strategy and how you can do this with avoiding major legal and commercial risks that we commonly see in this field. Laura and I are both UK trademark attorneys, but actually we help clients globally with work in the UK, EU and beyond. I think it's important to note that the topic that we're discussing today, it's not unique to the UK. It applies to businesses throughout the world. Similarly, just to add that this isn't going to be an overview of the legal landscape. We're looking at the commercial practicalities of brand development from an IP perspective. So just as a brief summary of the sort of agenda of the topics that we're going to be looking at today. So we'll start off with a brief discussion of what we mean by brand development and when is IP relevant. We'll then move on to look at what we might mean by what is a brand and what intellectual property might exist in that brand. Looking at it from a practical view and considering some of the common pitfalls that we see in brand development, we'll look at the steps involved in creating a new brand, expanding an existing brand, and that's expansion into new products, new markets, and then reviewing and refreshing an existing brand. We'll then go on to look at what legal can do to help with these various steps and when to involve them. We'll look at the importance of documenting the decisions that are made throughout the brand development cycle. And then we'll wrap up with a conclusion, looking at some of our sort of key takeaway tips from the areas that we've discussed. And as Mona already mentioned, we'll have a Q&A session at the end. So just to reiterate, if you have got any questions as we're going through, please feel free to pop them in the question box on your dashboard, and we'll answer those in our Q&A at the end. So to begin with, what do we mean by brand development? So in preparing for this webinar, I sort of came to realise that brand development can have a lot of different meanings depending on the context in which you're talking about it. The quotes that you can see on this the slide are the definitions that I felt most closely aligned with what I had in mind when I was thinking about brand development. It's what's clear is brand development is an ongoing process. Most successful businesses will continually revisit and review this. It's about so much more than IP, but IP rights provide an invaluable mechanism to really protect the very heart and soul of the brand. Failing to consider your IP in your brand development process really means you risk falling at the very first hurdle. So when is IP relevant? So IP considerations can be triggered throughout the brand development process and brand lifecycle. The trigger points really do vary, and they're different depending on the nature and the size of your business. But the most sort of common situations where this will be triggered is obviously the initial creation of the business or product itself and the development of the founding brand. The growth of the business as you introduce new but perhaps related products, or perhaps moving into completely new product areas altogether. Again, expansion into new geographical markets, a review and refresh of existing brands, and then I think importantly also streamlining the portfolio by removing products, reducing market exposure, and potentially even discontinuing a brand altogether. We'll come on to look at each of these in a bit more detail, where we'll discuss the most common pitfalls and risks that we commonly see in our practice for each of these areas. So to start off with, what is a brand? And when might what IP might exist in that brand? So the brand identity and makeup of every business is really unique to that business, and it's shaped by various factors, including the market and the strategy of that particular business. You might have a business where you have just one brand, or you may have multiple brands and sub-brands. But today, when we're talking about a brand, we're talking about each of those individual brands. As to what IP might exist in any given brand, again, it will depend on the brand itself, but some examples you can see on the screen here. So your name, your logo, strap lines, general brand livery, packaging, and the design of product itself. And then I think moving on to perhaps some less some areas that are perhaps less commonly thought of as IP, your domain names, social media handles, even recipes, production or manufacturing processes, any marketing materials, instruction manuals, and sounds, multimedia elements, and even scents. Now, ultimately, the type of protection that's available for all of these different types of IP will vary by jurisdiction, but regardless of where a business is based or where they operate, the existence of the IP itself is really universal. You might find that in some jurisdictions you can't protect some of these elements, but regardless of that, it's really important in the early stages to make sure you assess and understand what IP actually exists, and you can then consider what steps can be taken to protect the value of that IP, even if that's not necessarily through registration, as an example. So looking at our sort of our first obvious example of brand development is creating a completely new brand. So this might happen at the initial development of a new business, or it could happen throughout the life of the business as it evolves and diversifies. We sort of see four main categories of mistakes in this area. So you can see those on the right-hand side of the slide. And the first one of these is really failure to identify and recognise the value of the IP. So at this point, I will pass over to Laura to share some of her experiences in this field.
Okay, so for many businesses and startups in particular, it can be really easy to be put off protecting IP by the potential costs that could be incurred. And also businesses think that it's perhaps not something they need to worry about at the early stages of their evolution. So there is no hiding the fact that protecting IP does involve spending money, but it doesn't have to break the bank, and costs can really vary quite greatly. Also, costs and investment in protecting IP can be done strategically, so that costs can be spread. we often see businesses presuming that they can't afford protection or advice, so they ignore IP altogether, or even worse, sometimes they try to handle things themselves and end up in an even more expensive position. At any stage of your business, IP is so important because it is a valuable asset, and protection of your IP is a way to protect that investment and the brand and business. So we recognise there may not be budget for securing registered protection perhaps at the early stages of a business's life. However, we do really strongly recommend that clearance searching is carried out and prioritised for every new brand development. A failure to conduct proper clearance searches could lead to you being on the wrong end of a lawsuit and a costly rebrand if you end up having to sacrifice the brand that you've already started to develop.
Yeah, and I think it's important to note actually that's relevant even for established businesses. I think when we're thinking about costs, we quite often think, if it's a new business, they've got strict budgets, but it's relevant to established businesses, especially in times like we're facing now, where there's a lot of economic pressures, and businesses are finding ways to limit their spending. Often we see, and Laura, I think this will be the same for you, we see that despite the critical and valuable nature of IP, this is often an area where budgets are reduced. But I think it's important to keep in mind that you can save costs in this area by reviewing your IP strategy or your service suppliers in this area, and that's a better approach than sacrificing things like Laura's just mentioned, the clearance searching, which is really such a critical part of your brand development and your IP strategy. So whether you're starting up a business or you're part of an established business, considering IP and setting aside a budget really is a critical step to being able to recognise and protect the value of your IP, and this really should be made a priority. We'll later come on to discuss why to involve legal and when, but for now I think it's just to note here that actually legal can really help in this process of identifying IP and prioritising the critical steps. As Laura said, sometimes we see clients try to do things themselves and it ends up being a lot more costly, whereas if you involve legal early on, they can help make sure you avoid mistakes, but also help set and control your budget in this area.
Yeah, this is also important when you're thinking about other less well-known types of IP, which can be just as important as the core trademark or brand. So often the focus can be on the brand name and perhaps a logo, but there are less obvious types of IP, such as the general look and feel of the product or its packaging, some taglines that are perhaps unique to your brand, or even technical features which might warrant design or patent protection. And these can be just as important as the trademark itself. Some of these elements of IP have strict time limits for securing protection. So if you miss these at the outset, that could have far-reaching consequences for your business, and it could leave you open and vulnerable to either attack or to being in a position where you can't defend your rights in the future. So as well as those other IP rights, we also see business overlooking domain names and social media handles because they don't consider these as part of their IP strategy. Failure to consider these elements might mean that you don't secure them and you're unable to secure them, perhaps for the lifetime of your business. So it's really important that when you're looking at clearing your brand name, you're also considering whether these now really important marketing tools are also available. Having a strong IP policy in place and using IP management tools can help reduce the risk of not identifying the relevant IP and prioritising budget for the important steps in brand development, because it provides consistent guidance, so people are always taking the same steps each time they're going through this process.
Yeah, absolutely. I think as I was just mentioning the IP policy there, I think that's something we've already mentioned a few times, and it's going to be a repeating theme throughout today's webinar. But having an IP policy is really so important for businesses, and I think it's often overlooked, particularly for startups and smaller businesses that perhaps think it's something that's really reserved only for the biggest of brands. But I know from my experience that actually even the small startups can really benefit from having an IP policy in place from the outset. So one of the areas that IP policy will generally cover is looking at your clearance checks, and that's where we see our second mistake here on the slide, and actually I would say one of the biggest pitfalls that we see businesses tripping up over in their brand development process. So for anyone who's not familiar, clearance checks is basically a process where you run some searches to assess whether the use of your particular IP rights might conflict with any earlier rights that are already in existence. If there is a conflict and you still end up going ahead, you could end up in a situation where you have a potentially lengthy and costly dispute, and ultimately you might end up facing really significant costs and potentially PR repercussions involved in having to rebrand and potentially even withdraw from the market.
Yeah, I mean, sometimes clients come to us and they say, oh, we're comfortable that there is no conflict. We've done some searching. We can't see any issues. We've seen situations where even if a client has carried out a search of the relevant trademark register and done an online search for any existing brands that are using similar marks, they've not really been able to recognise what might be problematic. So from their perspective, they see an earlier registration or somebody using a similar brand name and presume that because it's not identical to their mark or even as close as they might want it to be, they don't see it as a problem. They think that these businesses are using a different mark and they're going to be fine going ahead with theirs. So without conducting this type of search through a professional, there is some risk that you might not recognise what's problematic from a legal perspective. That's why we do recommend involving a professional legal at this stage, because we handle these matters every day. We can see how conflicts are developing at the Intellectual Property Office and which way decisions are being made. So we're better placed really to assess what's a legal risk. And we can be far more objective about the results of searching. I think once a business has committed to a brand name, they often find it very hard to let go of that name, even in the face of a big obstacle. And so we can be a little bit more objective and perhaps raise stronger concerns than perhaps somebody within the business might do. We can also carry out the commercial element of the search as well, so carry out online searching, which covers domain names and company name registrations, which aren't directly a conflict in terms of trademark registration, but might indicate that there's someone else operating in the same field that is using a mark that's too close to yours, and that might have commercial and also legal repercussions. So moving on to the next point. Oh no, sorry, going back to that point, that there is a way that people can conduct their own screening searches. Like I say, sometimes clients come to us having already done that. And there's nothing wrong with carrying out these screening searches. They are a good first step, but we wouldn't recommend that they're used as a guidance for launching a product. The places that you can find those types of databases are the UK Register, and also there's an online tool called TMView, which is free to access and can give you some guidance. And it will give an indication, these tools give an indication as to whether a rethink is required before more in-depth searching is instructed.
Yeah, I think it's also worth noting that in addition to the tools that Laura's just mentioned there, which are freely available for everybody to use, there's also kind of a middle ground from using those free tools to engaging full legal services and doing the full clearance checks. That there's certain subscription tools out there. For instance, there's a Markify Pro Search, which is basically a paid-for database, and it generally has a broader reach and a better similarity algorithm. So when you're searching for similar marks, it's able to pick up more relevant hits than perhaps if you're just doing using the free databases. I think this can be a really useful tool, especially for perhaps for more experienced IP owners that can do that sort of initial assessment of understanding whether or not there is a, likely to be an obstacle. I think even with using these, you still will end up taking it to legal to get an opinion, but it can at least give you an idea, especially if you're considering, you've maybe got 5 names on the table and you're not too sure which one to go for. Doing these initial screening searches before you involve legal can ultimately save you quite a lot of cost and time in your brand development process. I think I'd also just add that one of the key things here, which we've mentioned, is starting the checks too late. And this is something that we see a lot, even with businesses that understand the importance of conducting these clearance checks. We often see clients coming to us to begin the clearance process once everything's ready to go and the launch is imminent, and this is far too late. Again, as I said, we'll come on to it later talking about when to involve legal, but this is really one area that you should involve legal as soon as possible and as early as possible in this process. If you don't do that and you wait until you're too far down the line, you might ultimately have wasted a lot of development cost on a brand that will ultimately be blocked. And that kind of takes us on to quite nicely this next point here about not balancing the legal and commercial risks of a potential name. So as we've talked about, the clearance checks will identify any potential conflict risks that you might have with your proposed use. When you get the results of those clearance checks and you see what conflicts there are, you have a number of options of how to proceed, and ultimately how you do proceed will depend on the risk attitude of the business. There's some businesses that are very risk averse and will not want to take any risks, and others that think, I'm going to go for it and I will deal with the consequences, and that's really a business decision that's, as I say, down to your attitude towards risk. But I think the main thing to take away is that a legal conflict doesn't necessarily mean there's a commercial conflict, and this is a really important balancing act. And this is where I was saying we're not just going to look at the legal landscape, but we're going to talk about the commercial practicalities. And I think this is a real area where it's so important to balance the legal and the commercial.
Yes, when we're conducting searches, often we see marks that are raised in the search, existing registrations that cover goods or services in the same class as the one of interest to our client and the new business. But that doesn't necessarily mean that it's going to present a commercial risk to the client's business. From a legal perspective, it could be perhaps relied on to oppose an application to register the mark. But when you look more closely at what the business is actually doing under that brand, it's perhaps operating in a different field or in the same field but in a different niche area. And actually on the market, there wouldn't be any commercial conflict. So looking at the commercial activities of the person behind the registration or the brand behind the registration really gives better insight into how much of a risk an earlier mark might present. Similarly, some applicants like to cover very broad terms in their registration when they're protecting their mark, and it may be that what they're actually doing is very narrow and in an entirely different field to you within that sort of broader area. So again, conducting investigations into how the mark's being used really does help to establish whether the kind of degree of risk that this earlier right might present. Another thing that we sometimes see is where a mark is still on the register, but it's not actually being used anymore. In the UK, once a mark has been out of use for 5 years, even if it's registered, it's very difficult to rely on that right. So it may be that the mark was registered some time ago, the owner of the mark's moved on to a different project or pivoted and using a different brand, but the mark is still sitting on the register. So just because it's there, it doesn't mean it's problematic from either a legal, in this case, or a commercial perspective, but particularly from a commercial perspective, because the person behind that mark may not want to invest time and money in blocking somebody else when they've got no interest in it themselves. Another thing to bear in mind is that sometimes an application is filed and the mark is registered in one form, but over time its use evolves and it's used in a different format. And again, that may make the registration vulnerable to non-use cancellation, depending on how different the use is to the registration. but it could provide some scope to negotiate with that party and to challenge their registration. It might also indicate again that the commercial interests of the party have changed and they've rebranded slightly because what they were doing previously is no longer of interest to them and they've moved into a different sector. So just because there's something on the register that maybe look like a legal risk doesn't mean that it's presenting a risk from a commercial perspective.
Yeah, I think one of the things that's is also important to think about, and this is particularly in markets where an earlier registration would act as an obstacle to your own registration, regardless of whether or not the earlier owner takes any action. So it's not the case in the UK. In the UK, the earlier owner would have to actually formally oppose a later application, but there are a number of markets throughout the world where that's not the case, and an earlier registration on the register, regardless of whether or not it's actually still in use or commercially is of any interest to the owner, would act as a block. And so you're then, in those situations, you're perhaps in a situation, in a position where you maybe can't overcome that obstacle for whatever reason. Maybe costs, maybe budget restrictions stop you from being able to negotiate, get consent or file a non-use cancellation. And it might be that you can't get your own mark registered, but the mark has still been cleared for use. And I think, again, this is something that I see quite often, that there's so much weight placed on the possibility to get a mark registered, but actually the decision about which brand you're going to move forward with, the IP that's involved, it's a careful balance of the commercial and the legal risks against the viability of that brand with your consumers. So from a trademark perspective, the best name might not actually, so the best name from registering the trademark might not be the best name for your consumers. And I think ultimately, providing your brand is clear to use, registrability really is a secondary consideration and shouldn't be given too much priority in deciding which brand to move forward with.
Yeah, and it's worth keeping in mind that sometimes there are alternative ways to protect intellectual property if on the face of it it's not registrable. So a good IP strategy will look at these alternatives and the mechanisms available to address this, for example, common law rights and potentially other types of IP. So if disclosure has ruined the patentability of a product, there may be options to protect it under design law. If a mark's descriptive, then you might be able to register it in a different format and then look at seeking protection or the descriptive element at a later date once you've got some established use. So just because a mark isn't registrable now as a trademark doesn't mean that that's the end of the line. There are other ways that it can be protected. So looking at the next and final point on this slide, failure to consider ownership of all aspects of IP. So the final big mistake we want to discuss in this area is a failure to consider ownership of IP. So even the most experienced IP owners overlook issues around licensing, copyright and unregistered rights. Registered rights might clearly be under ownership of one party on the register, but can be in use by another, either as party within the same group, a different part of the business or a separate entity altogether. We also see at the start of a business that sometimes managing directors register rights in their own name, but actually during the life of the company, they're used up by the company itself. So the intra-group use is one of the biggest areas we see being overlooked. The law does allow for implied licenses in many jurisdictions, but this isn't the case everywhere. And the use of implied licenses can leave you open to vulnerability if you need to rely on that right.
Yeah, I think just on that point, Laura, so I think one of the big vulnerabilities that you see with the implied licenses really comes up with when you're thinking about unregistered rights. So again, this isn't relevant in all jurisdictions, but there are a number of jurisdictions throughout the world where you acquire rights through use of certain types of IP. But in a situation like you've just described, where you've got the use is by someone that's not the registered owner and there's no formal license agreement in place, I think it's really important that brand owners are thinking about what's going to happen with those unregistered rights, who do they vest in. And I think connected to this as well is thinking about the situation where maybe you've got a third party that's helping prepare branding materials. So maybe designing your logo, creating your web page, flyers, brochures, that type of thing. All of these will benefit from copyright protection, and that arises sort of automatically when the work is created. But there's then the question of where does that ownership vest? And I think, again, just coming back to our recurring topic, an IP strategy can really cover a lot of the issues around ownership. It can be addressed in your strategy. And actually, issues of ownership really can significantly deplete the potential value of your portfolio. So it's a really important area to make sure you're thinking about. And actually, as a worst case scenario, you might find that some important IP ends up actually being owned by an unconnected third party, and that third party might then be in a position to block your use and future plans for the brand. So talking about future plans for the future plans for the brand, looking at expanding the brand. This is our sort of next topic area, and here we're talking about expanding into new product areas or new geographical markets. We see a number of issues here, and we've listed 3 of the biggest mistakes we see on the slides. Firstly, assuming your existing use or rights gives you a free pass to make the expansion. So IP rights generally are territorial in nature, and just because you've been cleared and using brand in one market doesn't necessarily mean that you're going to be okay to go into a new market, and it's likely that clearance checks are going to be needed. This is relevant for geographical but also products category, and I think here it's really important to consider whether or not the new product that you're considering moving into is far enough removed from your existing use to maybe mean that new clearance checks and registrations might be needed. And I think this is something probably where involving legal is so important, because actually the question of similarity between products is quite nuanced, and that's really something that legal can help guide you through that process. And I think here one of the biggest things we see is to make sure you're thinking about whether or not there might have been another brand on the market that previously commercially you've been coexisting because you're just sufficiently far apart, but then maybe your plans are going to take you closer to that business and you end up then in a conflict that wouldn't have existed otherwise.
Yeah, so this is particularly relevant when we go back to the point that some legal conflicts are not commercial conflicts. It might be you're launching a related product where the earlier right is technically in legal conflict with your mark and earlier use, but commercially there was coexistence and that was viable because of the differences, the perhaps subtle differences in how the mark was being used. So it may be that new expansion will cross that line, and the earlier rights owner that previously wasn't problematic might seek to block your use of the mark for the new product. Similarly, businesses need to make sure they're aware of any disputes which have already arisen, in particular if an agreement was reached which might stop the planned product expansion. Often when we're in the throes of negotiating settlement with other parties, the short-term aim, which is to clear the current brand and use, may take over from considering any future use. So if a formal agreement was reached where you agreed to not use the mark on certain products or in certain areas, if you start to do this, there is the IP issue, but also you're looking at contractual disputes over the nature and scope of the agreement.
I think actually the point that you've just made there, Laura, about thinking about the short term is actually one of the really big things that we see, that a lot of businesses in their initial brand development are perhaps too short cited, that they are really thinking about the here and now and what their immediate plans are. But I think it's really important to make sure you are considering the medium and long-term plans as well. Appreciate that you might not be in a financial position to search and register in all potential markets. That could be a very costly process, but I think it's really important as a business that you at least understand the risk of not doing those checks, and think about what you would do as a business if ultimately you do find that your future plans for expansion are blocked. And we've got here on the slide 2 ways that you can kind of manage the risk in this area. So firstly, thinking about having a different brand for different products and markets. So maybe the having one brand name in the UK and another brand name in France.
Yeah, an example of this that's quite well known is the Jif Sif product. It was launched in 1969 in France, where it was called Sif. But as the brand rolled out across Europe, and because kind of think local was the prevailing strategy of the day, there were minor variations to the name that had to be made to get around barriers in various jurisdictions. And so it ended up being called Vis, Vim, and of course in the UK we called it Jif. So at least the familiar packaging was more consistent across the brand, but not completely. In the Netherlands, it was orange and red in honour of the Dutch royal family, but the colour of it did harmonise the branding to some degree. But of course, businesses that are managing different brand names for the same products in different jurisdictions can save time and money by harmonising their trademark portfolio. So you may have to use different names in different jurisdictions, but keeping their management under one roof helps to make sure that they're being managed consistently. I mean, this isn't always possible.
Yeah, I think there's different reasons for having different brands in either for different products or for different geographical markets, and it's not always because there's a block. It might just be, as with the Sif Jif situation, that one name resonates better with particular consumer base. But I think nowadays that as our sort of market borders are blurring more, that type of split in branding is becoming less common. But ultimately, if you do have a block, that might be the way that you have to go. And there's quite a few examples in the market. For instance, there's the Irish fast fashion chain Pennies is actually called Primark outside of Ireland, and that's because of a conflict with the American retailer J.C. Penney. Burger King also had issues launching in Australia, and to this day still goes under a different name in that market. But ultimately, as a business, when you're thinking about your brand development, I think, and you're thinking about your initial clearance strategy and things, I think you need to ask yourself whether or not it's viable for you to have different brands in different markets. Is it something you're prepared to do? And if not, and you're not prepared to rebrand post-launch, then it really is critical that you are making sure you're conducting these initial checks in all of your core markets of interest before you launch in any market.
Yeah, ideally it would be highly advisable to file applications in all core markets as early as possible, even if use might not commence for some time. Filing the application will mark your flag in the ground, and you might find otherwise that you clear the mark at one point in time, but when you come to register it, something's cropped up in between. So conducting the clearance search and then going straight ahead with the filing would actually be the ideal way to proceed in that situation. So the second point on this slide is that we see another way to manage the risk is to avoid making compromises and agreements which will block future plans, which we've touched on already, but it's a different one to balance because compromises are often made in agreements and people are keen to move forward with their branding, and if it's being blocked, you want to get around the obstacle. So the mistake that a business might make here is not to think about where the brand might go in the future. There's a balance to be struck between reaching the agreement for the short term and the need to ensure that your future plans aren't unreasonably blocked.
Yeah, I think just to add here as well, Laura, this is, I think it's about more than just changes to trademarks or markets of interest as well. I think it's also about anticipating maybe technology developments that might impact the interpretation and scope of the agreement. We've seen in recent years the pace of technological developments is just getting faster and faster, and with that, agreements that were reached perhaps at the end of the 90s, early 2000s, there's now grey areas, or some places where there's no coverage whatsoever. And so I think it's really important to make sure that any agreements you do enter don't unreasonably restrict potential future development, but also that they include a provision to allow you to kind of renegotiate and agree terms for developments that might not have been foreseen at the time of the original agreement. So I think if we're moving on to our, I'm conscious of the time, so if we move on to our next area, which is reviewing and refreshing an existing brand. So brand developments, it's more than just creating new brands, as we've already talked about, and it's a continual process, and brand owners really need to keep this under review. We've sort of talked about a few, you can see on the slide there are a few different areas that we've suggested are considered. I think in terms of the value of your IP, here one of the big things is to make sure that your protection is still sufficient for what you're doing, and whether or not there might be any issues, like we talked about with the ownership, that's potentially decreasing the value of that IP. And I think it's important to not just look at your own brand, but to also look at competitors. And this is a critical step to staying competitive. It gives you an opportunity to observe trends, assess what works, and tailor your own strategy accordingly. It's not about copying, obviously, but it's ensuring your strategy is informed and remains competitive. A lot of brands do this by monitoring the market, but another way that you can do this is actually through IP watching. So in particular, when we're watching for new applications that have been filed, this is a really good early indication of new product launches which are coming to the market.
Yeah, and bearing in mind those topics, you might decide that changes are needed to your branding. So changes to the brand itself, which could be minor from an IP perspective, or may involve a total brand refresh with the new look and new name, or changes to the brand strategy might be necessary. Even if the brand itself isn't being refreshed, the brand strategy might be updated and could mean changes to ownership, licensing agreements, monitoring, and enforcement approaches. So in both of these cases, there are other questions to consider, and we've set out those on the bottom half of this slide. So are there any known agreements or blocks to your new branding? Is a new clearance search needed? Does the existing registered IP give you sufficient protection? Does the existing IP need ownership to be updated? Do you need to change your monitoring and enforcement strategy? And can you streamline your portfolio? Does the new branding give you the opportunity to review and perhaps make smart decisions to ensure you're not wasting resources on protecting, maintaining, and enforcing irrelevant rights?
Yeah, and I think again that's an area where legal can really help with streamlining the portfolio. Again, a bit like you were talking about earlier, Laura, with the new brands and the clearance, with us being able to be a bit more objective. I think it's the same here. Sometimes a historic brand the business might have a real connection to and want to keep, but ultimately if you're not using it, or if it doesn't match how you're using it, it might be that it's better for the business to let it go, and that's really something that legal can help with. And looking at what legal can help with, it's really important that you involve legal in the brand development process and involve them as early as possible. We often see mistakes where legal's only involved when an issue's actually come up, or as I've talked about before, until everything's ready to go and launch. And I think in both of these situations you can end up having to incur a lot more costs than if you'd involved legal early on. And I think one of the biggest things as well we see is expecting the best from the legal team without actually giving them the critical information to understand the overarching commercial goals and strategy. Ultimately, we want to be proactive and be able to help you anticipate all of the issues and to leverage your IP as best as possible. And in order to do that, we need to know what your commercial goals and strategies are. So I think it's really important to treat your legal team as a strategic partner that's involved from the outset.
Yeah, things that legal can advise on early and with full knowledge, as we've discussed already, are things like identifying the IP, conducting clearance searches to make sure that they're carried out properly, starting this process late or missing out altogether, as we've already discussed, can be costly. They can also develop a filing and enforcement strategy, which strikes a commercial balance. So involving them early and with full understanding of commercial goals will help them to develop and prioritise an approach to ensure you're spending money on the most efficient way and focused way in respective critical activities. They can also help you to recognise cost efficiencies through streamlining the portfolio. So there's a lot of value and investment made in protecting IP. So sometimes the simplest action in this area can help bolster that and make it even stronger. And developing and implementing commercially focused strategies. So getting the most out of your IP. I've left one out, sorry, anticipating and reducing vulnerability in the IP portfolio. So looking at where there may be a need to refile a mark because it hasn't been used for some time and it's about to be launched again, is an example of how someone with legal understanding and knowledge of the situation can add some value in this area.
Yeah, I think I think one of the things, just whether you've involved legal or not, I think documenting the decisions is also something that's really important and can be overlooked. So brand development can involve a lot of different contributors and teams, and often the reason for the decisions are not well documented, and as time passes, personnel change, the rationale for the decisions can be lost, and that can cause problems for brand owners. Given our time, I'm not going to go into these in detail, but effectively you're looking at situations where having a bank of evidence and a place that has got all of that rationale decided can save you cost and issues in the long run. So in terms of how you document those decisions, Laura, I think you were going to have a little discussion about tools like brand proposal.
Yeah, so Questel's brand proposal solution is a collaborative software to not only tracks and documents decisions, but it can improve the workflow and collaboration of the parties involved in the decision-making process. Part of Questel's IP management software offering, and it provides, like I say, a collaborative workflow for trademark and design development. It's a customizable tool, so the workflow and stages and roles can be tailored to your specific needs, and it can be used by everybody within the process, not just internal contributors. It allows a defined workflow to be followed, and it provides central storage location to store the decisions, but also the rationale for those decisions, which, as Vanessa's flagged, is really important to understand. So the loss of this kind of knowledge of the decision-making process can lead to inefficiencies and can mean that critical background is missed and brand development decisions are made which have costly consequences. So whichever approach you choose, having a clear process and documenting the decisions is kind of invaluable for your current and future business, and it allows greater legal and financial certainty in the journey of your brand.
So I think with that we're on the final stretch now. So apologies that we've run over. We'll try and wrap up nice and quickly for you. So I think hopefully today's webinar has shown you not only the importance of brand development, but also how IP plays such a critical role in that process. Whether it's from the first idea through to reviewing a well-established brand, it's a continual and complex process with many factors involved. IP is just one of those, but one that is easily overlooked or deprioritized, and that can have potentially disastrous consequences. So our top tips and takeaways from today, which you can see on the screen here, plan for the now and the future, so consider your short, medium and long-term goals. Clearance searching should always be given a priority, even where budgets are tight. Involve legal early and with full knowledge of the commercial goals and strategy. Utilise legal to help develop an IP strategy that's commercially focused and will help prioritise your IP activities and spend in a cost-effective way. And finally, document your decisions, giving you greater commercial, legal and financial certainty and accountability in the journey of your brand.
Yeah, as we've discussed, IP rights provide an invaluable mechanism to protect the very heart of the brand itself. So setting out a strategy to be used by the business when developing your brands ensures there's alignment between teams and that decisions regarding protection and enforcement are made consistently and at the right point in time. If you have an existing IP strategy in place, we would be happy to carry out a review to ensure it still matches your branding and business goals. Equally, if you do not currently have an IP strategy or policy in place, we would be happy to work with you to define a robust and sensible way to approach brand development alongside IP protection. With this, I'll pass back over to Mona for some closing comments. I'm not sure we've got time for a Q&A session, but if anybody has a question, we can see if we can get to that now.
Yeah, I think if we don't have time for the Q&A, or if anybody thinks of some questions afterwards, please feel free to email them through, and we'll do a follow-up Q&A by email, so we can send around the answers to any questions that we haven't had a chance to cover today. So just before we pass over to Mona, just a big thank you to Laura for joining us on the webinar today, and also to all of our attendees for sticking with us even though we've run over time. So back over to Mona.
Thank you, Vanessa. Thank you, Laura. So I would like to draw your attention to a helpful resource. Oh, okay. I was going to mention our IP newsletter. There we are. Perspectives. It's full of strategic guidance and updates on important industry developments. As you can see, you can sign up to our newsletter via the website shown on this slide. So if you require any IP advice following the webinar, please don't hesitate to reach out to me, Vanessa, or Laura, or any of our experts at Novagraph. So we do have do we have time for the couple of questions that we had in earlier, or are we gonna?
I think we might need to wrap up, so we can, if it's okay, we'll because I can see a few people have already had to drop off, so we'll send a follow-up round afterwards.
Sure. So, okay. So thank you so much from all of us at Novagraph for participating in today's webinar. Please feel free to contact us for further guidance on any of the information you've heard here today. And we hope to see you again next time. Goodbye.